You're listening to the Quint's podcast.
In a detailed judgment, a special NDPS court denied bail to Aryan Khan, son of Bollywood superstar Shah Rukh Khan, on grounds of him knowing others travelling with him were carrying drugs and that this amounted to quote-unquote conscious possession. The NDPS court in its judgment stated that WhatsApp chats indicated that Khan was involved in quote-unquote illicit drug activities for narcotic substances on a regular basis. But it's important to point out that no drugs were found in possession of Khan when he was arrested, and that WhatsApp chats the NCB provided as evidence are messages like quote-unquote let's have a blast. An outpour of support came for SRK and his family ever since Aryan Khan was arrested, and especially after the recent bail denial, with many on social media alleging quote-unquote police harassment. But why was bail denied by the special NDPS court given the lack of evidence against Khan provided by the NCB even after 2 weeks of custody? Why is it so hard to get bail under the NDPS Act? Is this really a case of police harassment or is bail being unreasonably denied? To analyze the latest developments in the Aryan Khan drug case, we spoke with the Quint's legal editor Vakasha Sachdev and Dr. N.C. Asthana, who is the former DGP of Kerala and ADG BSF and CRPF. You're tuned in to The Big Story, the podcast where we dissect the headline-making news for you, and I'm your host, Himmat. Just to give a recap to our new listeners, Aryan Khan's bail has been rejected 3 times since his arrest. First was right after his arrest on 2nd October. The NCB at that point stated that quote-unquote shocking and incriminating evidence was found on his phone. The second time was due to a jurisdictional issue, where his case was being heard by a local court in Mumbai. The judge in the case stated that a magistrate court does not have the jurisdiction to entertain a bail plea for an offence with a punishment of more than 3 years under the NDPS Act. Thus, the case was moved to the special NDPS court. And the third was, of course, on 20th October when the special NDPS court denied bail on grounds of evidence provided by the NCB. Now, just like the Riya Chakrabarti case of 2020, the NCB has claimed that Aryan Khan is part of a quote-unquote international drug racket and that there is a larger quote-unquote Bollywood drug nexus at large. And just like the Riya case where several other celebrities were also put under the scanner of the NCB, like Deepika Padukone, but were all later released, the NCB also raided Bollywood actress Ananya Pandey's house in connection with Aryan Khan case and called for questioning based on chats with Aryan. The NCB also visited Shah Rukh Khan's residence on 21st October to collect any more possible evidence. But in terms of evidence, we only know that the NCB has not recovered any drugs on Aryan Khan's possession and only small quantities of drugs from Arbaz merchant who was travelling with him. The NCB claims that it has also recovered questionable evidence found on Aryan Khan's phone. And based on this evidence, the NCB has argued against Khan's bail in the special court on the following points. First, the NCB argued that based on WhatsApp chats found on Khan's phone, there is a larger conspiracy of a drug ring and even an international trafficking ring. Second, it said that based on statements taken by Khan and Merchant, the former was aware of the drugs found in Merchant's shoes and that he was quote-unquote in conscious possession of the drugs which were allegedly meant for both of them. Now, the grant of bail under the NDPS Act is restricted under Section 37, and it is important to understand what this section exactly states and how in several NDPS cases it is very difficult to get bail due to the wording of the section. Dr. N.C. Asthana, the former DGP of Kerala, breaks down the section, the provisions of grant of bail, and how it is very subjective.
Section 37 is very clear that bail shall not be granted unless the public prosecutor has been given an opportunity to oppose the bail application. That's one. And second, when the public prosecutor opposes the bail, the court is satisfied. I mean, if the court is satisfied that there are reasonable grounds, I must lay emphasis on reasonable grounds within inverted commas, reasonable grounds for believing that he is not guilty of such offense and that he is not likely to commit any offense while on bail. Mm-hmm. So as you can see, there is a certain degree of subjectivity. Mm-hmm. Similar provision has been made in the section 43D bracket 5 of the UAPA also, which was introduced in 2008 following the Mumbai 26/11 attack. It was a knee-jerk reaction. Similarly, the NDPS Act also, as you are aware, it's one of the most draconian acts in the whole world. So, when this act was drafted, probably, the public has a right to question the wisdom of the legislature. They went overboard. The act was made unduly harsh. So, when the law is like that, trial courts are bound to apply the law in its letter. So, bail by the trial court will naturally be difficult. Without any bias towards anybody, that's the position. The law is like that, that bail would be difficult. It would be rare for a trial court to apply any discretion at this stage. Generally, only the high courts.
Now that we know what this bail section exactly states, does it apply to the Aryan Khan case? The NDPS court in its judgment, according to a live law report, stated that, quote-unquote, on the face of it, Aryan Khan was indulging in illicit drug activities on a regular basis, and that given this evidence, bail cannot be granted. However, Vakasha Sachdev, the Quint's legal editor, believes that the court accepting the NCB's arguments is strange, given that Section 37 has a certain level of leniency built into it, especially for small quantities in the Aryan Khan case.
So what we have to look at when it comes to this bail order, and what is, I think, the most problematic part of it, is that the judge has agreed that Section 37 of the NDPS Act applies here, and that's sort of why he's having to deny bail to Aryan Khan, Arbaz Merchant, and Munmun Dhamecha. However, this is a slightly strange thing to do, because Section 37 of the NDPS Act doesn't apply to all cases under it. I mean, there is a great degree of misuse. There is a great degree of problems with the way, bail is denied to many of the people arrested under the NDPS Act. It does have a very strict bail provision, but that bail provision doesn't apply to just sort of anything. So if you catch someone with a few grams of weed on them, that doesn't mean that you actually have to deny bail to them. There's actually a degree of leniency kind of built into that, because Section 37 of the NDPS Act, which does add, these onerous bail conditions, one, that, the prosecution has to be given a chance to respond, and two, that the court can't release someone if they're not guilty. That doesn't apply when it comes to offenses dealing with small quantities. That only applies to cases which are either, dealing with licensed manufacture of poppy and trade in that abroad. It deals with Section 27 capital A of the NDPS Act, which is financing and facilitating illicit drug traffic. And it deals with any offenses, whether it's possession, sale, manufacture, purchase of commercial quantities of drugs. Now, when we look at what happened with Aryan Khan, no drugs were recovered from him. Arbaz Merchant, 6 grams of charas, which is cannabis, well within the threshold for a small quantity, which is 100 grams. And when it comes to Munmun Dhamecha, there were 5 grams of charas recovered from her room. Now, if you're looking at these quantities in themselves, there's no reason why the bar and the sort of strict onerous conditions on bail in Section 37 of the NDPS Act apply. And that's one of the reasons why this case has drawn some amount of attention. It's understandable, obviously, that this should also be happening in other people's cases where small quantities are recovered and they're being denied bail using Section 37. But this is a case which is before us on that grounds. Now, the NCB's argument is that, look, these guys are involved in a conspiracy with other accused, and some of those other accused are sort of drug dealers and everything, and we've recovered a commercial quantity of a drug called MD from one of them. And therefore, Section 37 applies and the strict bail conditions apply, and therefore even these guys, Aryan Khan, Arbaz Merchant, Munmun Dhamecha, they should not be given bail. And the NDPS court has agreed with this argument, but that's not really it's not really a well thought through argument. Obviously the NCB is making it, but for the NDPS court to accept it is really strange, because there's very little evidence of any actual conspiracy. If you look at the paragraph where the judge is describing what is the sort of evidence which links conspiracy here, he looks at the fact that Arbaz and Aryan were in contact with each other, which is hardly surprising. They were friends. It then looks at the fact that Aryan Khan is supposed to have had conversations with unknown persons. Now, this is important. It says with unknown persons about drugs, including perhaps even about bulk quantities of drugs and even about hard drugs. But this is with unknown persons. Now, it does not actually say that any of these three were in contact with the person from whom a commercial quantity of drugs was recovered. So the person from whom it was recovered is accused number 9. So that's a specific person who is there in this case. Yet there is no mention that any of these three were involved in communications with that accused number 9. As we've said, from what they've read, what the judge has himself said is there in the WhatsApp chats, there's communications between Aryan Khan and unknown persons. Now, if that's the case, it doesn't make a lot of sense that this conspiracy can really be made out. The NCB itself in court, if you remember, had said we are still trying to ascertain what the conspiracy is. Here, when the court is accepting their claims, they're just pointing out that there are these chats here. Some people have disclosed they bought drugs from someone, and that's it. I mean, there's no actual basis. Okay, these guys were in communication. A was in communication with B was in communication with C, and they were all planning things. There's none of that here. So that's the sort of really weak link in this case, and one of the reasons why it's becoming so strange that bail is continuously being denied, because no real proof of conspiracy is being established.
The NCB in court also pointed towards the Riya Chakrabarti case of 2020, where she and her brother, Shovik, were charged with Section 27A of the NDPS Act, which deals with the facilitation and financing of drug trafficking. In that case, bail was denied to Shovik since there was an alleged evidence in the NCB's possession that showed he had a connection to a drug trafficking ring. But according to Vakasha, even though Shovik was denied bail in October 2020 by the NDPS court, it is important to note that the same court 2 months later also granted him bail due to lack of evidence of a conspiracy.
Look at what happened in the Shovik Chakrabarti case. Now, this is cited specifically by the NDPS court. They've said that, look, the High Court denied bail to Shovik Chakrabarti because there was a claim of conspiracy with drug dealers and peddlers, dealing in commercial quantities, and which possibly connected him to drug trafficking. Now, it's interesting because the High Court did deny him bail at an initial stage on that basis, but by December, the NDPS court, so that was in October 2020. In December 2020, the NDPS court itself, not even the High Court, the NDPS court granted him bail, saying that there is actually no evidence of this, there's no material to show this conspiracy. And that's, I think, even at the earlier stage in October 2020, at least there were specific claims that, okay, he is in contact with XY people. There were two people, I think it was Ahmed and Kezan or something like that. There were two specific people he was in contact with who were then, involved with drug deals, and therefore the High Court rejected his bail. That doesn't really, there's none of that here actually. Like, there's no specific allegations about who Aryan Khan and the others were in contact with and how that connects them to the person who had commercial quantities. So that's why this whole case really, there's a lot of questions now which are going to have to be taken up by the Bombay High Court when it starts hearing the matter on October 26th.
The cruise ship drug case has of course took social media by storm given its high-profile accused. In a swarm of fans, press and police, Shah Rukh Khan visited his son at the Arthur Road jail on 21st October. Fans of the Bollywood superstar also flooded social media with signs of support and slamming the NCB for quote-unquote harassment. The hashtag #IStandWithSRK even trended on Twitter on 22nd October. Even politicians have come forward and taken a dig at the NCB over the arrest of Aryan Khan. PDP chief and former J&K Chief Minister Mehbooba Mufti, in a tweet on 11th October, said that Khan's arrest was quote-unquote a travesty of justice and that quote-unquote central agencies are only after the 23-year-old simply because his surname appears to be Khan. Dr. Asthana says that the presumption of police harassment exists not only because of the high-profile nature of this drug case, but also because of the draconian nature of the NDPS Act and that the law is such that it lends itself to be abused.
My view on this is very clear. In fact, I had tweeted also on this in a series of tweets, and obviously I can't back out from my tweets. My position is that this tsunami of sympathy for this boy is essentially because of this culture, the subculture of Indians, star-struck Indians, which are obsessed with the vicissitudes of celebrities. Vicissitude is a slightly difficult word in English. I mean, the swing of fortune of the celebrities. People are obsessed. I mean, Bollywood and cricket. People are obsessed with that. So this outpouring of sympathy is largely a result of that. And I must qualify my statement by observing that under the NDPS Act, last year 72,000 cases were registered. And most of the cases are actually built upon such type of evidence only as you are finding in this case. Why is there no corresponding sympathy for those more than 72,000 accused in the remaining cases. I mean, simply because they happen to be poor or students or whatever. Because they are not celebrities, so there is no wave of sympathy for them. And coming to the second part, yes, the law is such that it lends itself to abuse. I wrote a full article in the Wire on this. The law is such that it lends itself to abuse. But that is a systemic problem. If people find that the law is badly drafted, they should put pressure upon the elected representatives of the people and make the legislature amend it. I mean, if at all we have to be outraged, we must be outraged about the fundamental problem, not about a selective case. I mean, every case deserves sympathy in equal amount. Why only this one case? And as far as your last part is concerned, harassment by the police, once again, malicious prosecution. I mean, I'm using a technical term for harassment by the police. Malicious prosecution means implicating people in false cases. This is a phenomenon which has been acknowledged by the Law Commission of India as well as the Supreme Court. It's nothing new. Supreme Court does admit, the Law Commission does admit that police implicates a very large number of people in false cases, destroys their lives in the process, and it's only after years that they are able to come out. In my last book on the subject, it's called State Persecution of Minorities and Underprivileged in India, I have cited as many as 385 judgments of the Supreme Court in that. Some of the judgments I would recall for you. The Akshardham case. Akshardham case, there were 6 accused. The main accused by whose name the citation goes, Adam Bhai as Mary Bhai. These people were given punishments ranging from death penalty to 3 of them and similarly heavy punishment to others. And the punishment was confirmed by the High Court. The Supreme Court accorded them a clean acquittal, not a technical acquittal. After considering all evidence, the Supreme Court accorded them a clean acquittal. But in the process, 12 years of their lives were destroyed. Similarly, there are other cases like Hussain Ghadiali. Hussain Ghadiali is the Surat bomb blast case. He wasted some 7 years. Then Muhammad Amin Khan, 19 years. Why is there not a corresponding wave of sympathy for these people? Merely because they do not happen to be celebrities.
Aryan Khan on 28 October moved the Bombay High Court against the rejection of his bail application. The court will be hearing the case in person on 26 October. Stay tuned to the Quint for more updates regarding this case. If you liked listening to this episode, please subscribe to The Big Story for episodic updates. We're available on Apple, Google Podcasts, Spotify, JioSaavn, and most of the other popular podcast streaming platforms. For other podcasts, please log on to the Quint website, and for any feedback, please shoot an email to podcast@thequint.com.
Thanks for listening. Log on to the Quint's website and check out our other podcasts.